I welcome the opportunity to talk on this debate, and I'll deprive Deputy Rory O'Murco of the pleasure of being the last speaker. But I don't know if I'd use the word pleasure at this point, but in any event, I welcome the opportunity. And there's a great need for this legislation, for this bill. But let me preface it by saying I'm standing here and I still don't know anything about the amendments date. It was raised in the Dáil when I was in my other role, and I shared the concern in relation to setting the date for the amendments before the discussion. And I'm still not clear. I understand that the time has passed. If it has passed, that's not a way to deal with legislation. So I want that on the record. Certainly nothing has been clarified to me in either role that I have, but I'll speak in here as a TD. And to say that amendments should be in before a second stage discussion is nothing short of shocking and unacceptable. In relation to your speech, Minister, and I thank you for that, you point out you set out what the bill, it replaces and simplifies the provisions of the Prohibition of Incitement to Hatred Act 1989 by creating a core offence that will criminalise any intentional or reckless communication or behaviour that is likely to incite violence or hatred against a person or persons because they are associated with a protected characteristic. One couldn't but welcome that. So I'm going to go through just the background to the bill as I see it and the issues, then the problematic parts with the bill itself and the reasons why I have the most serious concerns. Although I want to support the bill, we need the bill, and the way it's been done, I find myself in a position which is very difficult for me, not supporting the bill. And the range of, Deputy Matthew McGrath had particular opinions, I have particular opinions, other TDs have, and that range of opinions alone in this Dáil brings into acute focus what you have to try and deal with, Minister, and what your department has in terms of bringing forth legislation that's robust, that will protect the vulnerable groups and vulnerable people who suffer tremendously as a result of hate speech and hate crime, while at the same time freedom of expression. And that's the part that's missing in your speech, I think. And that's the part that I find more than a little disappointing, that this balancing of both sides has not been teased out. Now, normally I'm giving out about long speeches and you're to be complimented for your brevity, but on this occasion I would really have liked the department's thinking and your thinking on how this very, very difficult situation has to be balanced. The right to freedom of expression guaranteed by the Constitution, copper fastened in various Supreme Court judgments, High Court judgments, and by the by EU instruments and by international instruments. And nowhere has that been balanced or teased out for me in the speech. Unfortunately, neither has it been teased out in the legislation, which is very problematic for me, and I'll be coming back to that particular section. As usual, I want to thank the library for their tremendous work under pressure, and they've produced a detailed digest, once again one of the more detailed ones. So I want to thank the library and research. And they set out for us, which is evident itself in the bill, that there are 4 parts to the bill, 36 sections and 1 schedule. It has been said on the record here that the consultation has been not excellent, but there certainly has been a thorough consultation. I'd like to say that's not accurate. There was pre-legislative scrutiny of 1 day where people came in on 1 day and made all their submissions in addition to written submissions. Now, what has to be analysed here needs a lot more than 1 day. I have taken the trouble, the 1 day was in relation to the actual organisations or entities coming in before the committee, and detailed presentations from them and background. I've read as much as I can of it. I've read the Irish Human Rights and Equality one. I've read both from the Irish Council for Civil Liberties, and I've read as quickly as I could some of the other contributions. So if we look at all of the organisations welcome the legislation insofar as what the legislations intend to setting out to do, but have serious concerns about how that is being done. And of course, the Irish Human Rights and Equality Commission, it's very important to point out that they have a remit under law a statutory mandate to keep under review the adequacy and effectiveness of law in practice in the state relating to the protection of human rights, and to examine any legislative proposal and report its views on any implications for human rights and equality. So we have a statutory mandate on this organisation, and they've gone to huge trouble, 55 pages in their submission, to highlight their concerns. That was in relation to the heads of the bill. I know some has changed, some for the better, some not. And their submission focused on the following matters: balancing, which I've said, the prohibition on discrimination and incitement to hatred with the right to freedom of expression, addressing hate-motivated offences, and policy measures, which hasn't been mentioned much at all today in the discussion, the policy measures to respond to hate crime and incitement to hatred. And of course, they talk about policy measures because criminal law, as you well know, has to be a last resort. This is a last resort in our battle against hate crime and hate crime and hate comments. And so we're now looking at the last piece, which to me is not good enough, without looking at a whole framework, which every submission has asked for, a policy in relation to it. Countering racism and hate speech is imperative to the building of acceptance of diversity and respect for the dignity of all persons. Now, I come from Galway City, and we have the distinction of being the most cultural, multicultural society in the whole of Ireland. I think our percentage of population of non-Irish people is over 20%. It varies a tiny bit, between 19 and 21%. And the human rights go back and say it is important to emphasise at this stage that the legislative process, this is only one strand of the legislative and policy message which the state is required to take under our law, under EU law and under international law. Go on to point out that this legislation should be complemented by a broad set of policy measures and so on. I'm going to skip a lot of that. They point out that there's no specific hate crime offences in Irish law at the moment, which we know, which there was a gap. So what I really want to go on to is the freedom of expression. And the right of freedom of expression, obviously, as I've said, is protected under the Constitution, EU and international law. The European Court of Human Rights has found that the right is applicable not only to information or ideas that are favourably received or regarded as offensive or as a matter of indifference, but also applies to those that offend, shock or disturb the state or any sector of the population. Now, that's difficult for all of us to accept, that there's a right to offend, to shock, to disturb. None of us want to hear that, really, but that's something that needs teasing out. How do we allow for that and still not allow hatred or hate crime or allow somebody to suffer as a result of that? The right, of course, to freedom is not absolute. The UN Special Rapporteur on the promotion and protection of the right to freedom talks about a three-part test. So we can restrict the right to freedom of expression because it's not absolute, but we do so in a very careful manner. We do so provided by law, which is clear, unambiguous, precisely worded and accessible to everyone. This legislation, unfortunately, doesn't do that, Minister. It is not clear, unambiguous and precise. So number two, the UN rapporteur says, proven by the state as necessary and legitimate to protect the rights or reputation of others. Again, huge gap with data here, which I come back to if I have time, in relation to the data on hate crime and hatred on the ground. Number three, proven by the state as the least restrictive and proportionate means to achieve the purported aim. The least restrictive and proportionate means. This legislation is not the least restrictive. It's bringing in serious penalties, and proportionate it is not, in my opinion. It has given much more power to the guards in terms of search warrants and so on. The UN Rabat plan, which goes back to 2012, subject to correction, implies, among other things, that restrictions are clearly and narrowly defined and respond to a pressing social need. Of course, there's a pressing social need to stop hatred and hate crimes, but there must be the least intrusive measure available, or not overly broad, which this legislation is, and so that they do not restrict speech in a wider or untargeted. way. And again, what do they say? Only the most severe hate speech expression should meet the threshold of incitement to hatred. The UN Special Rapporteur has stated that only serious and extreme instances of incitement to hatred which would cross the threshold test should be criminalised. Now, there are many more comments from various European and international entities in relation to getting that balance and realising it's a difficult area. None of that, I'm afraid, has been addressed in your speech or in any of the documents other than the submissions made by the various entities that I've mentioned. In relation to the bill itself, I have a serious problem with a definition of hatred that simply goes around in circles. So what is hatred? Hatred means hatred against a person or a group. So we're saying hatred is simply hatred. I don't know what it means. Perhaps you do. I don't know. I'm not a judge. I don't know what a judge is going to make of that, but there's no definition of hatred here. I understand in the heads of the bill there was a more robust attempt to define hatred, which has now gone from the bill. In relation to the protected characteristics, which I welcome, there are 10 of them: race, colour, nationality, religion, national or ethnic origin, which covers travellers, descent, gender, sex characteristics, sexual orientation, which I understand were added after the heads of the bill, which is welcome, disability. Again, the Irish Human Rights and Equality Commission point out that other categories are left out. And again, I'm no expert, and I'm simply raising this in the manner that they've raised it. So civil status, family status, age, they haven't been included. And I'm not sure what the logic is to include some and exclude others. And at what point new entities or new protected characteristics can be put in. At what point can that happen? So I think when we're doing legislation like this, in view of the various, and I've only done a selection of them, of the importance of balancing the right, there's an onus to explain why we're including some characteristics and excluding others. And then if we move on to the repeal of the Incitement to Hatred Act is very, very welcome. Why is it welcome? Because it simply didn't work. That's why. And that's been pointed out to us repeatedly. It's been pointed out to us that there were very few prosecutions in relation to that. I think out of 44 prosecutions, there were a minute number of convictions. So it has been deemed, and I've lost the page, but we'll come back to it, 44 convictions, I think, with 44 prosecutions with very few convictions. So the 1989 Act, which people have said was ahead of its time, was a useless act. It didn't do anything for anyone. So how it can be called ahead of its time is beyond my comprehension. In relation to, I keep going through the bill, I have a serious, serious concern with the protection of freedom in paragraph 11. The only time that appears is protection of freedom is simply there in the title, protection of freedom of expression. Other organisations with vast experience and more knowledgeable than I have expressed serious concerns about this. Simply putting in one little paragraph with the protection of freedom in the title, and actually in a negative manner. For the purposes of this part, any material or behaviour is not taken to incite violence or hatred against a group or a group of persons solely on the basis that the material or behaviour includes or involves discussion or criticism of matters relating to a protected character. This is not a strong protection of freedom of information. And in fact, when you go back to provisions relating to offences under section 8 and 9 in paragraph 9, it sets out various defences, either there or elsewhere, which, in section 7. So in section 7.3, there's defences, reasonable and genuine contribution to literary, artistic, political, scientific, religious or academic discourse, and so on. If we had, and I agree with the Irish Council for Civil Liberties and the Irish Human Rights and Equality, if it was them that made the point, that if we had a very strong paragraph in relation to freedom of expression, we would not need to be putting in these defences because it would come under freedom of expression. So now what we have done is we have diminished freedom of expression rather than the opposite. Then if we move forward then to the presumption. the presumption, it's a very strong point where you're presumed innocent on proven guilty, and 99% of the time the onus is on the prosecution to prove. We are now reversing that here, and there's a presumption that has to be rebutted. We've done something similar in relation to the legislation, the title of which I forget, in relation to tackling illegal smuggling. We also put in that where we reversed the onus of proof, which to me was shocking at the time, and now we're doing something similar in this, and that's a step too far for me. If we go forward to search warrants, I believe section 15 has to be fundamentally changed or taken out. You cannot give that type of power to a district justice or anyone. And I understand it wasn't in the general scheme. If there are reasonable grounds for suspecting that evidence of or relating to the commission of an offence under 7, 8 or 10, the judge may issue a warrant for the search, and a named member could go in at any time within 1 week of the date of the issue of the warrant on production and reasonable force. Really, have we learned nothing? We have spent I don't know how long learning to rethrust the Gardaí. My first introduction to the Dáil was the O'Higgins report. I was nauseated reading what had happened in relation to McCabe. I've read the Charlton report. I've read the other reports. Have we learned nothing about giving absolute power almost to institutions like the Guards, the Dáil, ourselves? I put myself in that category, any institution. Have we learned nothing? I think, clarify the amendments for me, number one. Number two, in relation to this legislation, I want to welcome it. I really want to work with you. This legislation is vital in a functioning democracy. We've had the comments from the UN General Secretary of the United Nations, which have been quoted earlier on, how it's vital. Freedom of speech is vital to democracy. Freedom from speech, crime and hatred is also vital in a democracy, because if you don't have freedom of speech, we don't have democracy. If you have people who are so terrified because they're the object or the subject of hate speech, our democracy is in trouble. That's why a number of meetings on the Justice Committee was absolutely the most basic ingredient to teasing out what we need in relation to this legislation. There's no provision for a review. I'm not sure. I was in the chair last night and I heard a whole discussion on a review of a piece of legislation, which eludes me at the moment, the name of it, and a review was built into it. Usually the standard reply is legislation is reviewed every year anyway. But last night, in relation to the last night there was detailed debate in relation to a review of the new PIAB legislation, and no detailed debate here in relation to a review of this legislation. Now, if I could go back to the figures in relation to the reporting of hate crime, and it's the invisibility of hate crime, the invisibility of the suffering that victims suffer. And I want to emphasise that, Minister, here, that hatred and hate crime, what people suffer on the ground, is simply intolerable, and we need legislation to prevent that. But the balance is essential, and we're doing that in a vacuum with no data. One of the documents that I read said the Guards published its first official statistics following the introduction of its new reporting system in 2022. 2022 was the first time, and that indicated that there were 389 hate crimes were reported to the Gardaí during 21, in addition to 59 non-crime hate instances, comprising 448. The Guards themselves acknowledge that underreporting is still prevalent. And indeed, the documents that are before me calls for alternative ways of letting people report on what they're suffering. None of this, of course, has happened. Well, perhaps some of it has happened, but yeah. The common theme from everything I've read is that we need a pillar of measures, a suite of measures necessary to combat hate crime and hate speech, and that this legislation, or any legislation, is seen as only one part, and indeed that it's seen as a last resort. That's not what's happening with this bill. We're reversing in part the burden of proof. We're not protecting freedom of expression, And we're bringing in a piece of legislation that's wide open to abuse in terms of the search warrants by the guards, in terms of people being targeted on the ground for their views. And I'll finish up by saying, we've had the latest from the priest down in Kerry or wherever it was. I think of that. I think counter-narrative is the answer to that, is my own opinion. Then we have the Salman Rushdie, still suffering as a result of the book he's written. And then, of course, we have the comments coming back to us, more than comments, when we dare to speak out on what Israel is doing in relation to Palestine, and we call it apartheid. And suddenly all the letters come in threatening us in relation to what we're saying. So that is all part of this picture. I'm over my time, so I'll stop in mid-sentence.